You're welcome back. This is Newsfile. It's your most authoritative news analysis show. And here on Newsfile, we put Ghana first. Before we move to the next issue, I need to read this. And I'm not saying it's coming from a judge. And it says that a judge who sweats in his chamber without air conditioning, a judge who is not paid fuel allowances for 4 years, a judge who is not paid book allowance, a judge who lives in rickety accommodation, a judge who has not seen a hike in his salary for the past 4 years, can that judge too be effective and efficient? Something drastic must be done, and now. Right. Okay, so if Ace is on the line, we should speak to him first on what the Occupy Ghana got from the Supreme Court after over a year in the Supreme Court of battling one issue that led even Occupy Ghana to assist to promulgate rules or regulations for surcharges, disallowances, which Occupy Ghana thinks the non-exercise by the Auditor General is a result of the repeat of malfeasance, acts of malfeasance and reports in the report that go unpunished. It says on the line.
I'm here.
Right. So that was sweet for you, and you must still be celebrating that.
Actually, it wasn't at all. It wasn't at all. It was most humbling. And I experienced, like loss of adrenaline. Because this was a completely needless battle. We needn't have gone to court for this to happen. We've been battling this for 3 years. The provision has been in the Constitution since 1992, and since when the Constitution came into effect on 7 January 1993. The failure refusal on its leg of successive Auditor General to implement this is embarrassing, it is mind-boggling, it has no logical explanation. Look, they said things to us that they haven't done it because the article says may. They said things to us that we've done it before. We asked for an example, they gave us one case, and that wasn't found properly in accordance with the procedure that has been put in the Audit Service Act. So it got thrown out of court.
What exactly is this surcharge and disallowance?
What it is this, that whenever the Auditor General of Ghana, now this is a very unique power, whenever the Auditor General of Ghana, as a result of an audit, detects that some government expenditures have been made which are illegal. What is the example of the illegality? Parliament is approved. It's in the budget. 1, 2, that some money that should have been entered in the books somehow didn't get entered in the books. Or 3, the state has lost money due to somebody's criminality or negligence. Then the Auditor General will say, I disallow the transaction that led to this, and I am surcharging the official and every other person who was involved in it with that amount, and the person should come and pay. Then when you go to the Audit Service Act, it says if he issues that certification, the person has 60 days in which to pay or appeal. If the person does not pay and does not appeal, then it becomes the job of the Attorney General to take the person to court in civil proceedings as if it were a simple debt. Now, at the back of all of this is also the superior power of the Attorney General to say that if you are taking the government's money under any of these circumstances, it is the most glaring example of causing financial loss. And so, in addition to you being required to pay in the civil court, in a particularly egregious case, I'm going to charge you with the offense and put you before court with the prospect of you going to jail.
Okay.
But this is a very important tool because there was a section of the Court Act that I was very uncomfortable with, but has come to my mind again in these past days. Section 35, which says that if a state official is arrested and put in court for causing economic economic losses or financial loss, that official may meet with the Attorney General and offer to pay on terms. And if the Attorney General accepts the terms, those will be accepted by the court in lieu of the person going to jail.
That's right.
But if the person defaults on it, the person is making a beeline to jail. I think that the combination of these laws, Article 187, Section 17 to 20 of the Court Act, and Section 35, Section 17 to 20 of the Auditor General, and Section 35 of the Court Act, can be put together to be possibly the biggest corruption planting tool in the history of the world.
But there are people who have issues with Section 35 of the Court Act, that you go and then you plead guilty, you are asked to pay the money, do reparation, you pay interest on the money, and then you are sentenced, but you are not put to jail. That's not enough deterrence.
It is a double-edged sword. I have held that view for about a week or two ago. Then I said, yes, that do still prevails. But within the peculiar circumstances of this Auditor General work, it might come in very handy.
Okay.
My view was that the legislature smuggled it in to try and blunt the edges of corruption south of state actors. But it might come in very handy now. And now let me explain this. We are waiting for the full judgment. Fortunately, they still don't have it. But there's a part of the ruling that suggests that the Auditor General can go all the way back to 1992.
What?
We raised, it suggests that. Because they said all the reports. Now, we have raised that issue for the court to tell us whether or not the enforcement of the penalty or the fine or the damages can go beyond 6 years. Because this is actually a constitutional liability, not a statutory liability. And so will the Limitations Act affect a liability that is constitutional, because you look at the hierarchy of laws. Now, that I believe the answer to that will be in the main judgment when we see that. But let's assume that the judgment said, no, the Auditor General can only go back to 2011, which is 6 years from now. That means that all the losses between 1992 and 2010 are forever lost. My view, however, is that because there's no statute of limitations applicable to crime, all those who dipped their hands in our money between 92 and 2010 have committed the offense of causing financial loss. If they are private people, there's no statute of limitations, there's no bargain, there's no deal, we should try them. If they are state officials, we should start charges and then do plea bargaining under Section 35 of the Court Act.
But practically, is it possible to go as far back as you are suggesting and to, bring all these people in and to make the demand?
Absolutely, if you want to do it. The report exists.
Does the Attorney Generals, that the Auditor General, do they have the resources? Do they have the manpower to be able to execute such a, an ambitious thing you talk about?
My quick and almost flippant answer is, as they say in Vietnam, it's kind of difficult. If we look at the amount of money that is missing, it only makes sense to invest in this procedure to recover our stolen money. And if you look at the ultimate aim of it, that people will begin to realize that you just can't get your hands into the state coffers. Even if all it does is to make corruption less easy, we have achieved a lot. And with our just conservative estimates, they're talking about 40 billion Ghana cedis here. What amount of money can we not spend to get this for the people of Ghana? Some of the amounts are very small, some are very huge.
Okay.
Read the report on GIDA. 200 million cedis was taken from state coffers with parliamentary approval and spent on a sweetheart company. Okay, so Ace, you expect the Auditor General to start forthwith complying with these orders of the court? Oh, he will. I hardly do this, but the current Auditor General, he has a number of things to his credit. And if you talk to anybody in the audit business worldwide, he's very well known for his principles, for his stance, and the fact that he's a professional. Okay. He's completely unaffected by political ways. Now, this man quit his UN job to come and work in Ghana. Because the two presidents, that's what people do not know, both President Mahama and the then incoming President Akufo-Addo spoke to him and said, please do this work for this country. Now, to his credit, our Article 1877, we have to go through Supreme Court before it is ever properly enforced. This man took it, suggested it to the government of Zambia, who passed it in Zambia, and have been using it effectively in that country.
Okay.
So we passed the law and refused to ever implement it. Zambia literally stole that section, planted it in their Order Service Act, and have been using it. So this sergeant, the disallowance and surcharge has been going on in that country on a law that we passed it.
Right.
And the person who behind that, everybody in the South or every sector tell you, was the current Auditor General of Mr. Daniel Domelovo. So I have a lot of confidence in him. I know that in preparing for this, he has taken some of the staff to the Judicial Training Institute to be taught on evidence gathering. He's spoken with the police. He's spoken with lawyers. He's just waiting.
Right.
I think he's the
we are speaking to him. We are speaking to him immediately. So thank you very much, Ace, and thanks to Occupy Ghana for the service done to God and country.
Well, right. It's for Ghana.
Right. Thank you. Okay. So Ace Ankuma is a leading member of Occupy Ghana, and that's the victory they have won for the country. And we're speaking to the Auditor General right about now, Mr. Daniel Yao Domelovo. He will join us, and I'll be asking him a very simple question. I'm sure that they are aware that when the Supreme Court make orders and you don't follow them, you are getting into an offense known as high crime. You could be looking for prison for so long, and when you are out, you may not be able to get into public service until 10 years afterwards. So when are they going to start implementing the orders of the Supreme Court? That will be my question. I want to hear. Yes, okay. So good morning and thank you for joining us on Newsfile, Mr. Daniel Domelovo.
Good morning.
Great. So when are you starting complying with the orders of the Supreme Court to get our monies back?
Sorry, I didn't get the question clearly.
When are you going to comply with the orders to get the monies back for Ghana?
Let me say that before the Supreme Court ruling, we had started putting our systems in place. We have a team which went for training at the Judicial Training Institute.
Yeah, Ace Ankuma has spoken about that.
Say again?
I said Ace Ankuma has spoken about what you are referring to right now, but go ahead.
Yes. So that is the start. Let me say, we cannot just get up and say, bring 20,000, bring 1 million, etc. We have to do a meticulous work by building a file which has all the evidence to support each of the cases.
Why? The reports are already there, and the report has, you know, as it were, implicated these officials.
You cannot use a report to as an evidence in court. If I charge you, for instance, and you don't agree with me, and you go to court, I cannot pull out just my report to say this is the evidence of your embezzlement. I must go to the source document and show that you signed this voucher number so and so for this payment, invoice number this, and the goods were not supplied or were supplied less a certain quantity, etc. So it goes far beyond the report.
Yeah, you did the audit, so those reports must be with you, the source documents.
The reports are with us. The source document, yes, is with the audit service, but it is scattered all over the country. We have offices in the regions, the districts, everywhere. And mind you, when you are going to do an audit, any professional auditor will tell you that you have only one audit file for each assignment. So that file has a lot of other information.
Okay.
Now, we have to go back into the file to extract that evidence before we can go ahead and touch it.
So
it's a bit of a professional way. It's not just a matter of looking at figures in a report.
Right. How soon can we expect that you commence work?
How soon do you expect what?
Can we expect you to commence work, as in making the recoveries?
That's what I told you, that work has started already.
How soon can we expect that you will be calling on the specific individuals to come and pay up or account for whatever they have been implicated for?
Let me tell you that more than a month ago, we identified about 25 individuals we were going to call on. But when we went back to find out the current status, all of them had paid the money. Those who it was not payment, but we could not find source documents, they have submitted the document to clear the expenditure.
Okay.
More or less, the expenditure has been acquitted.
Mm-hmm.
So it is a continuous process. As we go, if we identify someone who has not paid the money or has not been able to provide documentary evidence to acquit the expenditure, that is the person we search. We just don't search that because maybe 4 years ago we identified an infraction and that has been rectified. We don't go back and into the search charge. So we go back and look at the current status. If the status remains the same, we gather evidence and then we search charge you.
Okay. But
the team has started doing that already.
Right. Have you seen the judgment?
Yes, I've heard of the judgment. I've asked for a copy. I'm yet to get a full copy, but I've seen extracts here and there in the newspaper.
Okay. But you can assure that certainly you will follow this to the letter and rake in all the money that has to be, paid back.
Let me say that I am committed to doing my work, and I have to do it professionally, and I will plead that nobody try to control or direct the way I do the work, because the work must be done well and done properly. It's not just a matter of saying that somebody has embezzled funds. You must prove it.
Okay.
He who alleges it must prove it. That is why I'm not just going ahead to issue certificates.
Well, the Auditor General has already alleged, so you are saying the proof also is sitting in your offices. So we can only hope that very soon, as you suggest, we will get some results. Thank you very much for your time, sir.
Yes.
Okay, thank you. And that's Daniel Yao Domilovo, who is the Auditor General, and Ace speaks very well of him, and particularly what he has pioneered elsewhere, and expects that he will replicate that in this country. And now he's got the full backing of the Supreme Court to do it, and to do it well. Yes.
I hate to bust our bubble a little bit. I don't know if he answered that question that we're talking about whether or not he has cited the actual judgment.
He says he's seen aspects of it, he's aware of it, they have applied for it, and he's waiting to have it.
I'm asking this question because I have seen several instances where a court does a ruling or gives a judgment, and we have not seen exactly what the court has said. The media misreports what the court is purported to have said, and then we move on an excited path that something is going to happen, only to find out that that's not what the court said. I'm reading the reliefs sought, and it appears to me, I have not cited it, but it appears to me that the reliefs were declaratory reliefs. That the court should declare that upon a true and proper interpretation of 1877B1, the Auditor General is bound to issue a disallowance and surcharge. That the court should declare that upon a true and proper interpretation of the Constitution 187BII, the Auditor General is bound. What's
the point? That this is not enforceable?
No, does this necessarily mean that from 1992 till now, what the Auditor General may have found as a misappropriation or an improper use of funds is pursuant to this necessarily recoverable based on this? That's A. Or does this mean that the provision in 187, which was initially written as may, is what the Supreme Court has just clarified to mean is bound, and therefore it means that moving on, it affects? I don't know. Yes. And that's why I'm raising this.
I thought Ace gave some clarity on that. And again, he also cautioned that we should wait and have the full judgment.
I agree. Let's wait and get the full judgment. But this is the whole import of this case. Okay, those of us who started this thing, we hit a snag because the constitutional wording made it a discretion.
Yes.
And our argument was that, given all that has happened, it goes from a discretion, has to harden into a mandate.
In other words, this case was just to look for an interpretation of what may actually means.
Not really. I don't want us to relate to it, but the point is that we're saying that the Auditor General has been derelict in his duties.
True.
And a whole avalanche of things have happened,
Right.
which have bled this country dry and will continue if he does not use his constitutional mandate and powers to save this country. And having declared an unwillingness to do so, Occupy Ghana felt he had to be compelled so to do. So first, he was approached. And he said, okay, come, let's talk, let's arrange this and that and that. They worked with them, tried to arrange these things, but it didn't still mean that they were going to do what Occupy Ghana wanted them to do. So they had to go to court for the court to compel them. Now, what I've read is that the court has granted all their reliefs. And their relief was the effect that instead of may, which you count as a discretion and may or may not do, now you are bound to. So now there is no room. Let's wait and see the actual language. But if it is not a situation where this has been hardened to a mandate, upon which if the Auditor General does not act, then he can also be cited, then really we didn't get anywhere.
I get you.
It has to be a ban.
Well,
But
but the man
implications of
himself
whether it
says
goes back
that
or
they
goes
have
forward.
been putting themselves in readiness to execute this already. So, and they are ready. They
Yes.
are ready with it.
Which is very important because honestly, Samson, that's the fundamental issue here. I have made this point and I'll make it again, that somehow our officials assume that they don't have to work. Because, like I said, this didn't need to go to court. The Constitution gave him the power. And you can see this same principle all across the place, where people have the power so to do. They take the perks, they get the money, they do everything, but they don't do their work until citizens compel them or go on demonstration or take them to court. Now, if even the ruling does not turn out to be what we are hoping it is, we're bound. Based on simply what is currently in the Constitution, Mr. Domelovo can go ahead and collect our money. And the same principle should apply to Galamsey, to toll levy. People should just do their jobs and not have to get citizens to get up. Like S is saying, sometimes you win these cases and you ask yourself, 3 years of struggle to get somebody who is paid to do a job, just to do the job. And you don't feel a sense of victory because you know what? Now we are going to come back to having to enforce this judgment. And if the same principle of people not wanting to work, okay, goes on, they will not do the work and we'll have to get up and go after them again.
At least you have the example of Citizen Ghana movement. You went and also got that victory on the information that had to be given to you, and it was complied with. So you should have the same expectation that there'll be
Let me give you some information.
Even that was high court.
That information was released.
Yes.
We had to go for it. It was complied with.
Right.
Because it was a specific judgment. That judgment has some sort of force on other situations. We are currently sitting on matters where we have asked for information from certain places and they're resisting it. And we may have to go back to court.
Because they are not bound by that judgment. Because the earlier judgment was specific to the Attorney General.
But you know, President, and we know it should be
Was the
binding.
Attorney General's report on the bus running released?
Not the Attorney General's report.
Yeah, I thought we were searching for it. We didn't get it.
Oh, if you want that information, come, we'll apply for it. By law, they should give it to you. What we wanted, okay, that judgment has that, effect of saying that if it is not national secret or whatever it is,
Under Article 21(1)(f).
Right.
please release it if it's requested. So let's request it. If they don't give it to you, we will go back to court and compel them to do so.
Thank you. Yes, Kuku, so what do you say about this Auditor General thing?
Oh, good. Really good. You know, when this Occupy Ghana and the Citizen Ghana movement, all those things started, I had the opportunity to appear on Occupy Ghana's platform at the Christ the King. And I said, look,
was moderating that.
that's right. And you see, I made the point that, yes, we've seen political, history of political activism, agitation, all those things over the years. But I saw a certain distinctive thing relative to Occupy Ghana and the new generation of civil society activists and advocates, apart from the fact that the middle class elements were coming out from, the word is escaping
Culture
me.
of silence?
Something like that. They were coming out. Something like they were asserting, and I thought it was very significant. There were people who were ridiculing that phenomenon, but I thought that was a very significant thing. And then they began to focus on issues, particular issues, using the constitution and the legal regime in the country to champion, to advocate, to insist. And I said, this is great for our democracy. And you see where we are going? Step by step. this is a great victory. It's the triumph of civil society activism and advocacy. And I'm really happy that I'm actually an associate member.
So you're a full member.
But you see, I've been checking on one or two things. Disallowance and surcharge, which is in the Constitution as well as in Act 584. I was talking to one or two experts in the field, and they were drawing a certain distinction between recoveries and disallowance and surcharge. You know, because I realized that there's a history of some recoveries that the Auditor General has made in the years past. Indeed, if Osafo Mafu was in Parliament on the 14th of, 13th December 2004 in response to an urgent question. But that one was after the government had commissioned the audit service to set up, to institute forensic audits into some companies and state corporations. And some recoveries were made by State Insurance Corporation and SNET and others, running into over 300 or 400 billion cedis then. But I'm told that when it comes to disallowance and surcharge, the punitive element comes in. It's like a penalty of a sort.
Okay.
No, so that apparently had never been done until Occupy Ghana has gotten the Supreme Court to deal with this matter. So it is good. Now, I've been asking myself, you know, the Public Accounts Committee and their findings and recommendations also became an issue as to why there hadn't been any criminal prosecutions beyond the Public Accounts team. Now, you know, subsequently, there was this agitation or debate that there was no financial tribunal to deal with it. Yeah. But the Chief Justice, in fact, the Judicial Service clarified that they had set up those things.
They even trained judges.
Yes, they've been trained judges for it. They've set up some in Kumasi, which takes care of the Ashanti and Brong-Ahafo region.
No case was sent.
The Sekendi takes care of the Western and Central. Tamale takes care of the 3 northern regions, and there's one in Accra. My last checks, it appears no case has gone to any of these courts. And that's surprising.
People don't want to work.
Okay.
Well, members of that committee themselves did not know that those courts existed, and that was terrible.
I agree with
yesterday
you.
You had questions too coming from the procurement minister suggesting that there was a need for, you know, some procurement courts. What are these courts there for?
Yeah, but you see,
actually the procurement court is the same as this.
It's the same thing. It's a financial court.
You see, the Chief Justice set up 2, apart from the financial administration courts. She also set up the Financial and Economic Crimes Court.
Same thing.
And if you read this correspondence, there's a press release from the Judicial Service. It's dated 14th February 2014.
Right.
Which was signed by Grace A. Tego, Mrs. Director of Communications. Subsequent to that, the judiciary sent statements to the Parliament, to the Speaker, and the Public Accounts Committee. I have them here. So they are aware. But of course, I'm not sure it's the Public Accounts Committee that ought to take their case to court. I'm not sure.
They complaining. They keep complaining that they are not courts.
Fair deal. But they ought to forward the package to the Attorney General for the Attorney General to deal with.
Or even tell the Auditor General to obey the law. Parliament can do that.
That is true.
Even censure him for not obeying the law.
So really, you ask yourself, why are we in this state of inertia of a sort?
Just a quick one.
It's because
looks like permanent inertia, really.
Yes.
So Samson, we need to start focusing on this thing about making people do their work. Because we can, look, yesterday's question about the procurement court was interesting. Look, in this country, when we have a problem, we pass a law or set up a new institution, staff it, and then forget. The Judicial Service has done a lot. These 2 courts, the Economic something court, and then the one that was set up, no case has gone there. Do you know that even in the regular court system, there is room for these cases to go?
That's right.
Look, if we even set up procurement courts, no case will go there. Now, let's be clear. People have to do their work. A quick one on Section 35 of the Courts Act, because I think it's a very important provision.
Okay.
2 and 4, subsections 2 and 4 solve the problem. Section 35 talks about how if you owe money, we find you guilty, you can come and pay the money, that will go. Section 35(2) says, where an accused person makes an offer of compensation or restitution and reparation, the prosecutor first shall consider if the offer is acceptable. Now, in that, the prosecutor will decide whether it's enough or not and whether there are other things to add. After the prosecutor thinks it is acceptable, 4 says, if the offer is acceptable to the prosecution, the prosecutor shall, in the presence of the accused, inform the court, and the court shall consider if the offer of compensation is satisfactory. So you see, 2 levels. So Section 35 is useful because, you see, when recently something happened concerning NCA, and the government's position was that we're interested in getting the money. This is what it's about. It doesn't say we won't prosecute you or anything, but there is the room first to get the money, because sometimes people go to jail, come back,
but this particular provision is not about dealing with the matter outside of the court. It is a matter that has to be dealt with in the court.
Oh, yes.
You are convicted, but you are not sentenced.
Yes. Okay. So I think we have enough rules, laws, institutions, courts, and everything.
In this country.
People must be made to do their jobs. And the last time I was asking Parliament, censure people, call them, ask them why you haven't done this, and then please put a bit of stake in the work of the police.
Michael Okwe, the speaker now, used to be a major advocate of censure. I suppose that he will put that into practice.
Just to conclude, you know, that February 14th release said the Financial Administration Court has, per Section 67 of Act 654, has jurisdiction A, to hear and determine matters that fall for determination under this Act. B, to enforce recommendations of the Public Accounts Committee on the Auditor General's report as approved by Parliament. C, to enforce contracts and bonds entered into in pursuance of this Act. D, to make such orders as it considers appropriate for the recovery of monies, assets, or other property due the Republic. E, to prohibit any individual, whether a public officer or not, from managing public accounts or funds if the individual is unqualified professionally or has been persistently negligent in the management of public funds. Then the last one, F, to prohibit any person from participating as a bidder in any government procurement or contract where the person has a record of defrauding the state.
We don't blacklist. Yeah. Sadly, we don't blacklist in this country. Yes, so let's hear you and then finish up with Kojo.
Yeah, I think it's a good news, like I have on the report here, or the statement here, said that the mandate has been there already, and they just have to enforce it. And all that we have said right now is about law. But coming back home, it is we as Ghanaians who have to be sincere to this nation that per our behavior and acts, this nation is losing revenue or money that hitherto should be used to develop this country. So it is very, very important, and we all back it, especially with the politicians, because many a times majority of Ghanaians think it is politicians who really squander, only politicians who really squander this country's money. So when we have a law like this in the statute books and is to be enforced on individuals, and then civil, let's say Ghanaians, including the politicians, I think it is the best thing to do. And that will help this country to go forward. But I still pray that our sincerity as Ghanaians to do the work, because these laws that we are talking about must be enforced. What if the person who is to enforce it refuses or becomes so adamant? That will not work for us. So we go around the globe and see and what good practices elsewhere. What are we doing in that case in our own country? It will surprise you that maybe this the AG may be moving forward to apply the law. It goes to a certain place. He may be frustrated by we Ghanaians, not a particular person, the same Ghanaians that have made these laws. When you go around the globe, they say, Ghana, we have very good laws, but why are we not applying them? The time is now. We need to crack the whip so that even if it is me, my children will learn a lesson. And that is the way Ghana can move forward. So we are expecting that a good job is done so that we retrieve, I could say, about 40 billion if we have this money. what can't we do in this country? Is it not only 9.7 billion Minister of Finance borrowed and we are shouting? Now 40 billion is here.
You are shouting.
So,
Okay.
we are also among.
Good point. Good point.
You are shouting.
So you will not shout?
No, I'm not shouting.
If it were to be, you shout more than
I have the
me.
details of the transaction.
Okay, yes.
Please permit me,
shout
because
more
I
than
think that
are not
you know
shouting,
the reliefs granted by the court in this particular matter are very nuanced, and we have to pay attention to it. Article 187 essentially has 3 different pillars. Let me start from the bottom. The third pillar has to deal with actions, financial actions that lead to a loss or deficiency, and the structuring of 187 said may, the Auditor General may. And I'm saying that, A, let's look for what the actual judgment is. But my understanding is that all that this ruling has done is to now, and if you particularly look at the 4th relief sought, now the Supreme Court has interpreted may to mean shall. That is what has happened in this case.
Yes.
It doesn't necessarily mean that, for example, this 40 billion that we are talking about is under this ruling recoverable, which now whips up some excitement, and then we all get disappointed in the end. B, the second one talks about people who collect money but fail to deliver it into government account. 187.7 BII says that now if the person fails to bring any sum into the government account, initially the scripting was may. The Supreme Court has now clarified that it is shall now. Literally, that's what it means. Now, the first part is where the problem still exists, where, if I just may read with your permission, 187.7 BI.
There are consequential reliefs. I'm looking for them for you because I think that solves the problem.
That's fine. But if I just may go here.
Okay.
It says that the Auditor General now is bound to issue a disallowance and surcharge where there has been any item of expenditure on behalf of the government that is contrary to law. What does that mean? We pass an Appropriation Act every year, which is the law that gives any government official the power to spend.
Yeah.
Now, governments over the years have been spending in breach of the appropriation law. Honorable, not true?
Sometimes.
Very, in fact, year on year, we even project deficits, we exceed the deficits. Things that have not been budgeted for, we spend. What this is now beginning to say is that when you do that, contrary to law, and the law allows violence, if you can vie and spend there, that's fine. But when you do that contrary to law, now you're going to be caught by this provision. But again, I take you to Section 96 of the Public Financial Management Act that was just passed. Now, it is literally a criminal offense because you could go to jail, be you a minister, deputy minister, whatever. Section 96(1), take G. If you fail to report even knowledge or information in respect of these matters to the appropriate authority or law enforcement authority, you commit an offense and you are liable on summary conviction to a term of imprisonment not less than 6 months and not more than 5 years, or to a fine not less than 100 penalty units and not more than 2,500 penalty units, or to both. We have enough laws. And like you said, the challenge now comes to the political will.
When you said we have enough laws, it just reminded me of repetition of a lot of stuff we have in the Criminal Offences Act.
In specific pieces of legislation.
Yes, because what is the difference between this and misprision of crime?
So that is why,
report a crime if
that
you
is
know
why
of it.
I'm guarding against this euphoria that the Supreme Court has said something and something has changed. No, we have enough laws
Before you
already.
proceed, let me
Yes,
read
sir.
what the Supreme Court says. That the Auditor General must issue disallowance and surcharge in respect of all state monies found to have been expended contrary to law. 2, the Auditor General must take steps to recover all amounts lost to the state, and this covers private persons. And finally, the Auditor General must ensure enforcement of the orders, including criminal prosecutions where necessary.
And this is declaratory.
No, these
must
are
do
consequential.
No, I mean, I
It's an
understand.
order.
Yeah, yes.
Enforceable.
Must,
Yeah.
must. But again, we'll probably have some time to do it.
Right.
I am not exactly sure that this, therefore, because you know there's
You
a
mean you
debate
can choose
about,
not to do it?
No, I'm not saying that. About whether or not this text in this ruling necessarily has retrospective effect. It's a different matter, but I don't want to
Let's
belabor
explain
that
that.
point too much.
If it's a crime, there are no limitations.
Yeah, and you may be minded by the clarification or clarity judgment that was sought in the election case when they went for the clarification judgment. These were this is the way they spoke in respect of their consequential powers.
Very well.
Right.
Now, for me, this is what it boils down to. It boils down to a political will to do this thing moving on.
Correct.
I am comforted by the fact that right from the beginning, the president in the State of the Nation address, the finance minister in the reading of the budget, government consistently talks about a certain fresh commitment to enforce these provisions, even minus some of these new ones that have come. I think that A, that is where we have to all look to and push towards. B, I encourage Occupy Ghana, Citizen Ghana, and a lot of these new civil society groups that Kweku's talking about, who have, done very well in using the courts to do some of these things. And my suggestion is that even if it comes to going for mandamus, to get some of these things done, where some public officials are being derelict of their duties, they should do so. Because we have talked enough, we have passed enough laws. The challenge now is about implementing
the prospects of jail will make people work.
It's the internal, if you take a look at the Internal Audit Agency Act, you see that that too is lying low. Nothing is happening. We're supposed to have internal audit units, MDAs. Go check it, and you see there are even disciplinary measures and things that have to be. We have to take another look there, and I'm appealing to Kofi them to start it again. We will support them.
I hear you. We go for a break here. I go for a break here, and when we return, I have said that broken down vehicles sitting on Ghanaian roads are responsible for 20%. I am learning that it may be more than that. 20% of crashes that kill and maim us. But why do we seem to have a certain disposition against a token levy solution to the problem? We'll be right back.